And so now we welcome Dr. Michelle Fernando, who's coming to us from South Australia. Oh, Michelle, here you are. But it's wonderful to see you again. Good.
Wonderful to see you too. Thank you very much, Jocelynne, for the opportunity to present here. I'm really thrilled about that. I'm a family law academic at the University of South Australia. My main area of research is really looking at how children are heard in family law matters, so including situations of violence, but also how children are heard more generally in proceedings. So I don't profess to be an expert in family violence, but I do have a fairly good understanding of how our current laws and processes affect women and children. Jocelynne's brief to me was really posing these three issues: where we were in the 1980s, where we are now, and what still needs to be done. And I think that's a helpful way for me to frame my presentation today. You will be hearing today from lawyers and survivors and supporters who have experienced the court's interaction with violent situations firsthand. So I think it's important to recognise that I'm not on the coalface. I don't have those stories. And so my role is somewhat limited to the laws and the treatment of family violence at that legislative, policy and procedural level. Now, we do hear a lot about the family court failing women and children, and I don't necessarily disagree with that, but I think it is important to recognise how far we have come. So if we go back to the 1980s, family violence was pretty much irrelevant when it came to the court's decision making, unless that violence was actually directed to a child. So there was really no recognition at all of the impact on children of the dynamics of family violence within a household, and no recognition of how violence can continue and does continue after separation, often through children. So violence really wasn't considered to be an issue at all, so long as it was between parents and not directed at children. And because once those parents had separated, it wasn't considered relevant. Now, thank goodness we have moved on dramatically from that point. And over time, we gradually see more and more recognition through legislation and case law and procedure of the real priority in family law of trying to keep children safe from harm and trying to keep their family members safe from harm. And this was particularly strong during the 2006 amendments to the Family Law Act and the 2012 amendments. Now, unfortunately, and I can speak more to those amendments if you aren't familiar with them, but unfortunately, the 2006 amendments, which was the Shared Parental Responsibility Amendment Act, also prioritised shared care. So we got this very diluted message where safety was being prioritised, but so was this notion of an ongoing, meaningful relationship with both parents. And that, I think, set up this false dichotomy where there was this sort of balance or trade-off between safety and maintaining meaningful relationships. And so the 2012 Family Violence Amendments to the Family Law Act were really addressed at fixing some of the problems that arose as a result of the 2006 amendments, where violence was very much prioritised ahead of shared care and getting rid of some of the very draconian laws that were brought in 2006, such as mandatory costs orders if you made a false allegation. So we come to the current law. So currently, the need to protect children from harm is a primary consideration under the Family Law Act when a court is making decisions for parenting arrangements. And it's also one of the objects of Part 7. Part 7 is the part of the Act that deals with parenting arrangements. Importantly, that prioritisation of children from harm requires the court to consider children being subjected to harm, but also exposed to family violence. So that makes it explicit that the violence doesn't need to be directed at a child. Also, in considering what is in a child's best interests, the court must have regard to a list of factors the primary considerations, one of which I mentioned, and also the additional considerations. And in those additional considerations, two of them specifically relate to family violence. One is that a court must consider any family violence involving a child or a member of the child's family. And a court must also consider any family violence order that has been made. So I think that puts it beyond doubt that a court must consider family violence as a very relevant consideration in deciding parenting arrangements and must prioritise children's safety when making those arrangements. We also have the definition of family violence in section 4AB. And in 2012, that was amended to its current state. It's actually quite an expansive definition of violence. It's a subjective and not an objective test, which is important. It's about a person being fearful, not a reasonable apprehension of fearfulness, which is what it used to be. It acknowledges specifically that children are exposed to family violence if they witness it or if they otherwise experience its effects. And that definition also includes examples of behaviours and examples of what experiencing effects of family violence might look like for children. In recent times, so I guess developments over the last 5 years, I think we have seen a real, delayed, but at least it has come, a cultural shift in the way that judges and practitioners and all people working in the system talk to or talk about and respond to family violence. So I attended a conference last year of the family law practitioners. So this is lawyers and judges from all over Australia. And this is the first time that I've attended one of those conferences where family violence was really upfront. It formed the basis of the Chief Justice's keynote speech and other people's speeches as well. And I think that does present a cultural shift in the way that that court staff are talking about violence, which is a really positive step. So that means that the laws that have been made over the years have made an impact, with a widespread recognition that family violence is a particular problem for family law. It's not just a safety issue that shows up from time to time that needs to be managed on a case-by-case basis. I think there's now that global understanding within Australia, at least, that that family violence is a particular epidemic in family law cases. So particular advancements that we've had over the last 5 years. One is the Lighthouse Project and the Evatt List. You may have heard something about this, but the Lighthouse Project is a process to screen for and manage risks of violence in family law matters. So it involves the parties to proceedings filling in an online risk assessment. And that project operates in almost all the registries around Australia now. And that identifies issues of violence as being of relevance in the case. And those that are identified as high risk are transferred to a separate case management list called the Evatt List. The cases that are in the Evatt List have different case management. So there's a real focus on expediency and safety. And the staff who run that Evatt List, so the judges, the court counsellors, and the registry staff all have or supposedly have specialist training in family violence issues. The Lighthouse Project has had some other effects as well because it exposes the full extent of the problem. So anecdotally, around 80% of people filling in those forms have, or one party filling in those forms, has highlighted family violence as being an issue in their case. So that the numbers are higher than we have previously thought them to be. And so this list is a positive step to shed light on just the full extent of the problem. I've written in my witness statement about the changes to the cross-examination rules. So as of a couple of years ago, a self-represented party may not cross-examine somebody in a family law dispute that involves family violence. So that's really important given that so many parties in family law matters are self-represented. which led to situations of women being cross-examined by their former abusers, or them having to cross-examine their former abusers. So now each of the parties has to be represented by lawyers who are paid for by legal aid. There are, of course, criticisms of that rule, including that some men are deliberately not seeking a lawyer so that they can essentially get a free lawyer. And of course, that leads to all the problems with people being self-represented when they don't necessarily need to be, and the delays and everything that that causes. But the most significant change to family law is happening at the moment, which is the Family Law Amendment Bill 2023, currently before Parliament. That bill is really, really important. It is the most extensive and most important set of reforms since 2006. Importantly, it winds back a lot of the shared care rhetoric, which we know put families in danger. It specifically repeals a presumption of equal shared parental responsibility. So that section requires currently a court to consider whether it's in the best interest of a child for the parents to have equal shared parental responsibility, and apply a presumption that it is in a child's best interest for their parents to have equal shared parental responsibility. And another requirement has also been repealed, which required the court to consider equal time and substantial and significant time for children with both parents. Now, both of those sections didn't apply if there was family violence, but everyone seemed to sort of miss that point. So firstly, the presumption of equal shared parental responsibility was widely and is widely thought to be a presumption of equal time, even though that's completely false. And the family violence exemption to that is routinely ignored. So that means for the majority of parents who are actually making arrangements for their children outside of court, they were really doing that on false pretenses and agreeing to arrangements that may not have been safe for children. So these are really welcome developments. Another thing that the amendment bill does is to simplify the factors that judges must take into account when making orders in children's best interests. So currently there's a very extensive list of factors that judges must take into account, and that's proposed to be taken down to 6 factors. And family violence commentators are a bit worried about this, because the one factor that talks about violence says that the court must consider arrangements that would promote the safety of children and people who care for the child. And that's really all that's said about violence, whereas, as I said earlier, the current list of factors contains some quite specific requirements for a court to consider family violence orders, past and present family violence. So the danger is, if we simplify those factors to require the court to simply consider the safety of the child, that we may be setting up a situation that could be a return to the 1980s position where judges would dismiss or downplay family violence as not being particularly relevant to future parenting arrangements, so long as a child is, in inverted commas, safe. So family violence commentators are worried about that aspect of the bill. So now we get to what I think are the main issues of lingering concern. I really think what it comes down to is the limitations of the law to deal with what is a societal issue, and this fundamental question of, if the basis of the existing law was created without any awareness of family violence or how it could possibly be relevant, then despite how many changes we make to legislation and how much we try to make this law fit, is it ever possible to ensure that family violence is addressed appropriately in our current Family Law Act? Or do we almost have to throw it all out and start again? I have no idea how that would occur, but do we need to approach how children's orders are made following separation from an entirely new base with our current understanding of issues such as family violence? So one glaring example of where the law is really failing women is in raising allegations of child sexual abuse. And this is because of a whole host of matters. But if you consider the nature of the subject matter, the fact that it's often characterised by a lack of forensic evidence, so-called unreliable disclosures by young children, it's in the context of a parental dispute where you already have issues of conflict and credibility. There's this legal test of unacceptable risk, which is a problem in itself. The law's continuing emphasis on shared parenting, even in high conflict disputes. And because of all these issues, mothers who form a belief that children are being abused by their former partners are set up to fail. In my witness statement, I have referred to the study that was conducted by Webb and her colleagues 2 years ago. And I note the limitations of that study, which the authors themselves note those limitations as well. But their findings were consistent with other studies that have been conducted in this area. And at the very least, the study raises some really disturbing issues because the numbers of cases in which an allegation of child sexual abuse is raised by one parent against the other parent is enormous in family law matters. But of those enormous number of cases that are reported, the number of cases in which allegations are found to be true, or in which there's found that maybe they're not true, but there's an unacceptable risk of abuse, appear very low, particularly when one considers how those allegations may be treated if it was in a context that was not family law. So, of course, that means that orders may be made that are sending children into unsafe situations, but it also means that women are at risk of losing their children if to an alleged abuser, and that it may be that women are being advised by their lawyers and others not to raise allegations because this could happen. And of course, that's contrary to the Family Law Act's priority of the safety of children. So this is an issue that really does need to be addressed. Another issue that I raised as needing work is a recognition of family violence proceedings being used as an instrument of family violence itself to coerce and control family members after separation. This is particularly so when the perpetrator of that abuse is the more wealthy party and has less to lose by perpetuating litigation and bringing continued applications. I saw this myself in a matter that I was consulting on to a very small degree. It was a Hague Convention matter where the child was brought by the mother to Australia. The child was nearly 16 years old. At 16, the Hague Convention doesn't apply to her at all. And the child expressed very strong objections to returning to her country of habitual residence. And in fact, she had pretty much been estranged from the father anyway, even in her home country. But despite that, the father persisted with a return order for the child, and the judge made that return order on the basis that the child's views were very strong, but he discounted those views as being the product of the mother. So the mother went through that litigation. She then appealed, and the appeal was unsuccessful because the full court found that the judge had applied the law correctly. Now, this then led to a situation where the child was about to turn 16, and literally on the day before her 16th birthday, she was being told that she would probably need to be at the airport to be collected by her father and taken back to her country of habitual residence. And when it came to the day, he didn't show up, and the mother was of the view that he had never intended to show up at all, and that had conducted the whole litigation as a basis of continuing to basically annoy and harass them from afar. So that was my own personal experience of seeing this, seeing litigation being used as an instrument of control. Now, the Family Law Amendment Bill, it is not an act yet, 2023, has sought to address this by introducing a new section that will allow the court to make orders to stop a person bringing proceedings if bringing those proceedings would cause harm to another family member And so that's a really positive step. But the Family Law Act is yet to recognise systems abuse as being a form of family violence in itself. So some family law commentators have recommended that systems abuse be added to the definition of family violence so it can be specifically seen as a form of family violence. So that's the end of my presentation. I can talk to my specific recommendations, but perhaps we'll go to your questions first. Thank you so much.
Thank you very much, Dr. Fernando. Really appreciate it. And so now it's over to my colleagues.
I have a question. I'd like to know how far coercive control, without the physical violence, but the emotional violence that is perpetrated on one party in a, how does that fit into the discussion of domestic violence? Where we all know it exists, but I can't hear it in what you're talking about there as being part of the problem.
Yes, we know it exists. The recognition of people working in this area, I think, is very strong. Whether courts are recognising it, I think, is a different issue. So I think it may be an issue that we see more about in coming years. I think we take it for granted that the law will always be behind the 8 ball when it comes to its the way it understands certain issues and the way it can try to apply them in the law. So I don't feel entirely optimistic about that, but I feel that the awareness will change, and it's certainly a discussion that's starting to be had.
It is. Thank you.
Thanks. Helen?
Oh, no, I'm still trying to take all that in. I think that the litigation warfare is very interesting. That, and especially that story you tell is so exemplary of that. So such a great story of that. But yeah, I thank you for your presentation.
Thank you.
It sparked a lot of thoughts with me.
Hi. So Michelle, you did mention that lawyers, when presented from their client tells them about child abuse, possible child abuse, and then lawyers are informing them that they shouldn't bring that forward or report that. Why is that? Is that something that's happening in the courts with lawyers, or a discussion that's happening where they think, oh, you're not going to get up? What?
So the concern is this is anecdotal at this stage. So we don't have studies that have been done on this specific area, but this is from talking with people who run women's legal services and that sort of thing. It's a warning, I guess, that so let's take this scenario. A woman raises, of course you're going to raise it. So you perceive something in your children, you think there's a problem. The Family Law Act tells you to raise it, so you raise it. And you form an unshakable belief that your former partner is abusing your children. The court applies goes through the process, and the court applies its tests, bearing in mind that the court has no investigative powers at all. So it's really trying to base this on the very limited evidence it has. And it's often found that there is no unacceptable risk of abuse to the children, that the allegations are unsubstantiated and that there is no what's called an unacceptable risk. So a mother hearing that is not necessarily going to change her belief just based on the court's finding. If she believes that it's happened, then in her mind it's happened. So how is she then supposed to react? She's then ordered to send her children back to this person whom she firmly believes has abused them. And that can lead to a situation where the mother then is perceived by the court to become obstructive to the point where she's unable to ensure that the father will continue to have a meaningful involvement in the children's lives. And as I said, under our current Act, there's a real emphasis on shared parenting and on the concept of a meaningful ongoing involvement in children's lives. And if the court feels like the only way that the children are going to have a meaningful involvement of both parents in the child's life is to move them to the other parent, that's what the court will do. I'm concerned about that because I feel like that is prioritising. It's almost like prioritising those allegations as being it. So saying, well, mum, because you can't accept that these allegations didn't happen, you lose your children. So it's not just punishing the mother, but it's also this sort of presumption or assumption that in moving the children to a parent with whom or who may have abused them, let's hope not, let's hope the court was correct, but whom they may never have lived with as the primary parent before, it's sort of assuming the children will be better off in that situation than they would be by staying with mum. And that's what concerns me. That I think it's almost this assumption, and this used to come through in the cases as well, although the judges wouldn't really say it now, but this idea that being falsely accused is the worst thing that could happen. You know? And of course, people who understand family violence and child sexual abuse are saying, no, sending children into situations with a perpetrator is the worst thing that could happen. Not an innocent person being unfairly accused. That's not the worst thing. The worst thing is actually sending children into situations of harm. So I don't know how we balance this. It's a very big problem.
I've got another question about costs. They're so prohibitive to many, great percentage of the female in a domestic situation, many of whom either have low-paid jobs or are reliant on the other party for their financial support. That means compromises are taken constantly about how far they can pursue justice or pursue what they claim, what they feel is their rightful claim, like shared custody or financial security of some sort. I don't know about South Australia, but in New South Wales, the hourly rate is well in excess of $500 an hour. How does an average litigant, or would you call them litigants in the family law court? Well, how does an average female pay and pursue their rightful share of both custody or of defending a family violence situation?
I have no idea. So unless legal aid assists, and I would hope that legal aid, even then, will assist people with very, very low incomes. But what about people who have quite low incomes, but not low enough to meet the legal aid threshold? So yes, that's a huge problem, and I believe that's why a lot of women are pressured into
accepting.
Yes.
Yes, I agree.
Well, we know that happens with property disputes for sure. Absolutely. As for parenting disputes, yes, I think that's the logical conclusion, that women are being forced into agreeing to things. And that, of course, leads us into how mediations are conducted as well, and the need for mediators to be attuned to systems of violence and control going on within mediations as well.
I want to say something really quickly about mediations. They should never, ever be conducted by one person. When I was an anti-discrimination commissioner, I made sure in the conciliations, which we can have a big debate about anyway, that there were two conciliators. One was a woman, one was a man, and I tried to get ethnic diversity, which I was able to do in that, because in a mediation, people see different things, and you need two people there so that they can actually at least comprehend much better what's going on, and you need the different perspectives, because there are different perspectives. But I just actually, if I could really quickly come to a couple of points, if I may. And this is actually your reference to the article, the study by Webb, Maloney, Smythe and Murphy, Allegations of Child Sexual Abuse, published in volume 56 of the Australian Journal of Social Issues at page 322. And this disbelief in the women saying that there's child sexual abuse. Now, we know from criminal statistics that in all crimes, it doesn't matter what it is, robbery, theft, online, etc., 6% of the allegations are false in everything. That means that 94% are true, and that's never a statistic that's recognised in these sexual abuse instances. And I just really want to quickly refer to Longman, which is a case from the High Court in 1989 and is the law in this country, where the judges of the High Court overturned a decision of a West Australian trial judge that the notorious statement by Hale, which is rape is a crime easily charged and hard to be defended against, however innocent the accused person, was being taken. The judge in Western Australia said that under the law it ought not to be a warning to the jury, and he didn't give it. The conviction was appealed against. The Supreme Court Criminal Appeal Court upheld the trial judge. It goes to the High Court, and those judges overturned it. And they reiterated Hale from 1736. His book was actually published in the written in the 17th century, published in the 18th. And ironically, that Hale has such a huge impact on the legal system, not only here, but he was referred to in Dobbs and Jackson when the Supreme Court of the United States last year overturned Roe and Wade from 73. So what we've got is this fixed mind within the judiciary, and unfortunately at the bar as well, that women are making false complaints. And as I said, we would accept that 6% may not be true, but 94% under the in any statistical analysis are true. But I just want to make that point because I think this study is so important, and all the judges should be reading it, and they should be required to read it and pay attention, and they should get Webb and the co-authors in to actually talk to them. So I hope they're doing that. But I just really quickly want to come to 2 points. One was the one about systems abuse, because you see, what we know as women is that we advocate a law change and we get it, like the Hague Convention, and then it's turned around and used against the interests of women, which are the legitimate interests. If we bring in this systems abuse, you know what will happen? That it will be used by the men against whom claims are made that they've engaged in sexual abuse of their children and exploitation. And I'm not saying don't bring it in. I'm saying, yes, we need it there. But we need always to be aware about the subversion of everything that we endeavour to achieve. But so do you think that may well happen? Like the point that you made, which was the other point I want to refer to, about the men now saying, ooh, I'm not going to be legally represented because I'll get a free lawyer anyway, whatever my income is.
Yes, I think it is a legitimate concern. And similarly, every law that's brought in, this is why these things have to be properly debated and really thought through. And that's what we're saying about this Family Law Amendment Bill is give us more time. It looks like it may be coming in this year and it's only just been released. And we're saying, these issues need to be thought through. So the systems abuse section that's coming in will allow the court to make an order if it would allow the court to bring an order to stop someone bringing proceedings if those proceedings would cause harm to another family member. So there is a danger that the court might interpret that as causing harm to the poor innocent father who continues to be accused. And also, if the recommendation of some of my colleagues that systems abuse becomes family violence itself, is recognised as family violence, then that sets up a risk as well that fathers will then be claiming that they have been systems abused by mothers. So they themselves are victims of family violence. So I think it is a legitimate concern, Jocelynne, yes.
And I think if I could say what an amendment needs to be made and a provision needs to be put in there that the judges in this area are compulsorily required to undergo training and education as to what this provision is about and what all these changes are about. And it can't be a one-off, a 1 hour or day. It's got to be regular because A, judges change anyway, some retire and new ones come on. But B, it's so endemic, this idea, the systemic discrimination against women it's endemic within the legal system elsewhere too.
Yes.
And therefore they have to be educated. It has to be at least once every year, and it should be more than that. But I would actually be advocating that, an amendment to this bill to say compulsory education, and not just by any old anybody, but by people who have some comprehension of what the realities are in this area. Yeah. But after that, do we have some fun? Maybe, I know that we've got our next witness, Barbara Clark, who's patiently waiting there, and you've been wonderful. Thank you for waiting too. Perhaps if, could you speak just very briefly about your recommendations, and then we'll go to Barbara Clark.
Sure, I don't think I need to speak to them very much at all because they're what we've talked about, and they just appear on page 5 of my statement. And to be honest, I'm not sure how to frame them properly because I don't know what the answers are. So I've said, number 1, that past violence must not be disregarded or minimised when ensuring children's future safety. So that relates to the amendment bill, which requires the court to consider a child's safety, but doesn't necessarily require the court to consider family violence that has occurred in the past. So I guess that's trying to make judges aware of that. Systems abuse needing to be explicitly recognised as a form of family violence. I think that's quite straightforward. And then the third one is this tricky one we've talked about, that women must be able to safely bring allegations of child sexual abuse without fear of losing their children. How do we manage that? I really don't know. The law, I think, is getting better. We've had a case last year called Isles and Nellison that sought to clarify this test of unacceptable risk, what it really means. So I think it's getting a little bit better, but still, if we've still got these real sort of, if judges are still really blind to the problem, thinking, no, this is really not happening, women are mistaken, you know, we can't be taking away contact from fathers, then I really don't know how things are going to move forward. It's a pretty bleak picture.
Thank you. Yeah, thank you, Dr. Fernando. But it's good that we've got women like you working in the area, and particularly in training other lawyers, you know, in the academic work that you do, because that's really important. Who are our new lawyers going to be, and how will they actually go about their job? Yeah. So thank you so much. I mean, if you're able to stay with us, that'd be great. But if you've got to go now, we understand that too, because we'd like to hand over now to Barbara Clark.